That brings us to item number 2, Senate Bill 134. Senator Hertzberg.
Good morning. Still morning.
Good morning. It's still morning.
Mr. Chairman and members of the esteemed committee, Assembly Committee on Judiciary. Every year, thousands of young lawyers, sometimes not so young lawyers, graduate law school, many of whom want to start beginning their career in public service of some form, whether that could be a district attorney, public defender, or public interest lawyer. But they are faced with a practical problem. Public school, we're told by your analysis, is $80-some thousand a year in debt. If you're not fortunate enough to have the money to pay for it, have somebody pay for it. Private school, maybe $120,000. What do you do? This is an issue that we have been dealing with for many, many years in the federal government. We started the Legal Services Corporation when President Carter got elected in 1977. And figuring out ways that we can encourage young people to provide that level of service in government. Because what they make in those jobs is a fraction of what you make going to a private sector job working for the establishment, so to speak. And so almost more than a dozen years ago, I introduced a measure that established a program through the Student Aid Commission that provided up over a period of 4 years a sufficient amount of money that we analyzed for students to be able to provide this level of public service. Because of the downturns and a series of reasons, it was never funded. As they say in the business, I'm back. And the issue still remains for public interest lawyers and government lawyers that have the same demand. The question is, what do we do? We have a governor who will, in my estimation, after knowing him for 40-some years, is not going to be somebody who's going to write a big check for this kind of program. He's not a big check writer. We offered in the initial amendments to be able to say, well, maybe lawyers can fund this on their own accord, that we can just have a checkoff system for state bar dues. We estimated we thought that would bring in, and so only to find out that the gentleman who has that dog by the name of Sutter downstairs is not in favor of that. So with the advice of the state bar, we said, what are other alternatives? Lawyers have these IALTA accounts, these accounts, interest on lawyers' trust accounts, that often gets cheated to the state. We looked at that because Oregon has done a similar type of a program, and but the impacts at first blush, as indicated in the analysis, look like they're not much. But when you dig in and do the homework, the impact on the average person is nothing less than extraordinary. The analysis says that even in the best case scenario, in extrapolating Oregon's numbers, you're only talking about 200 lawyers a year. Well, let me tell you something. If you talk to Neil Dudovitz over at the Neighborhood Legal Services, his 40 lawyers do 100,000 cases a year. What does that mean to people? It means that somebody who's being thrown out of their place can get some legal advice on unlawful detainer. It means that somebody who's being subject to domestic abuse can figure out how to fill out the papers to get a restraining order. Real impacts on people, real reductions on costs to society. And what does that cost? In the best case estimates, we know, and we don't actually know, but we have estimates that only 40% of these dollars actually get clawed back. So when you're looking at how much money it is, 60% is actually given up to the general fund. What does that mean in numbers? And what does that mean in cases? It means if you analyze over 4 years, when you look at what somebody makes, average $58,000 a year, what their take-home is of $3,800 a month, what their expenses are on a 20-year public deal, what they're paying $650 a month, how much money they're going to be reduced in terms of being able to afford this. You know what it results in? 40 cents a case. 40 cents in the worst case scenario, in the impact on the general fund, because it's money it doesn't get. If you analyze it based upon some other numbers, public counsel, other numbers, if it's only 500 cases, so maybe it's $2.50 a case. So you can look back and say to yourselves, well, this is not an impact. Where are you going to have an impact over a period of time of, is it 500,000 cases over an event horizon? Is it 250,000 cases to people's lives? Where are you going to get this level of cluck for buck, where you can take people who fundamentally want to work, who want to provide this level of public service, who want to start their career to learn about dealing with stuff on a day-to-day basis, and giving them that little bump of what it takes to make it work. And it's only based upon estimates, because these are dollars under the IALTA program that get cheated to the state hypothetically. Again, it's usually only 40% of the dollars that actually get paid. So I understand some of the concerns that were raised, but I don't think that the dots were connected in terms of what the real impacts are, on people, and where can you get this level of government service. And what's so frustrating, and the close on this, it really boils down to the kinds of things where we have developed through this legislative body over a series of decades very fundamental rights that are precluded from folks because they don't have access to justice. Because you don't have a young lawyer who's going to be a public defender to protect somebody, which is a constitutional right. Because you don't have somebody who can tell you how to fill out the form of how to get a protection if there's a domestic violence case. 40 cents to $2 in the worst case scenario. It is a wise investment. It is a place where we have as a fundamental premise of the law set forth in the Business and Professions Code. And every time Justice Reynoso swears in a new lawyer, he always reminds them of their obligations under Section 6001.1 of the Business and Professions Code, that it is the duty of lawyers to protect the public as their highest priority. I would argue that this is an important element at zero to no cost to the state and is simply connecting the dots. We'll introduce your witnesses. Whoever wants to go first.
Thank you. First witness in support.
Good afternoon, Mr. Chair and members. Pat Whalen, Ellison Wilson Advocacy here. We represent the California attorneys, administrative law judges, and hearing officers in state employment. Those are all of the attorneys and ALJs who are employed by the state, and they work and dedicate their careers to enforcing the laws that you good ladies and gentlemen enact from time to time. Many of our members, especially over the last 10 years, come to us as new civil service employees. Unfortunately, the state of California pays its lawyers less than virtually every major metropolitan local government. So we are losing out in terms of recruitment to DAs and public defenders, to say nothing of the private sector. Senator Hertzberg's proposal would enable many of our members to be eligible for some loan repayment assistance, and for that reason we urge you to support this bill.
Thank you.
And Mr. Chair and members, Mike Bellotta on behalf of the UC Hastings College of Law, well represented in this body, by the way. They're in an unusual situation. Hastings has a long history of public service. The students there go into public service positions at a higher proportion, probably than any law school, certainly than any law school in California, and they operate in probably the world's most expensive place to be in terms of housing costs and that sort of thing. So students coming out of there are particularly burdened while they want to serve the public. So we think this is a creative approach, and we support it, and we would ask for your aye vote. Thank you.
Thank you. Next witness.
Mr. Chairman, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office. For the reason stated, it is difficult for district attorneys and public defenders to both recruit and retain qualified attorneys. As the Senator stated, ensuring that public defenders, it's a constitutional right. Having good qualified district attorneys in order to protect society is important. I personally also sit on the board of directors of two crime victim assistance nonprofits. The work we do to help victims of crime not go on to public assistance, not to become homeless, is very, very important. And the attorneys that work with us do it all pro bono. But we've noticed over the last several years that the amount of volunteer hours that attorneys are being able to contribute is reducing very, very quickly because of their debts that they must repay. Programs like this won't solve all the problems, but it is a very good first step, and that's why we support this.
Thank you. Any other witnesses in support of the bill? If you could just give your name and affiliation, please.
My name is Brandon Biggert. I'm with the California Student Aid Commission. We support this legislation. I want to point out that 14 years ago, the differential between income and the student loan debt was significant enough to create this program. And 14 years later, that problem is only more pronounced.
Thank you.
And what I'd like to do is offer our support for the bill. Thank you.
Thank you. Anyone else in support? Seeing none, any opposition? Seeing none, bring it back to the committee. Mr. Wagner.
Thank you. Let me start by saying I'm extremely sympathetic to where you're trying to go with the bill. In part, I've got a daughter, thankfully out of law school without any debt, but who is in a district attorney's office, and I know from whence you speak, and there's no question that support needs to be found for these students, and it's a creative approach. Let me just throw out the two problems I have with it and get your response. First is that, as I understand the sheet law, money goes into the general fund, and the owner can make a claim.
Correct.
All right, so we've given it away to help with debt repayment, and then the owner comes back, so the money needs to come out of the general fund. I mean, essentially, aren't we giving general fund, ultimately giving general fund help to these folks? And is that really the best way to use the money, to use the general fund? And then the second problem I have is just with the mechanics of an IOLTA account. I mean, it's not even the lawyer's money that you're taking it from. It's their client's money. And so it's even a step removed from the normal sheet circumstances. And I mean, I would wonder why the bar even lets it happen. How can attorneys just let their client's money, essentially disappear to the state like that? Yeah. Shouldn't we be trying to make sure this doesn't happen rather than using it as a funding source?
It's interest money. Yeah. Yeah,
so,
with
there you
respect
go.
to both questions, certainly. Yeah, I think it is the best way to use general funds. First of all, Oregon does this administratively, and we didn't take it as an amendment, because I don't think statutorily it's necessary, but anybody, the Comptroller's Office would certainly or the Student Aid Commission would set up a reserve. We know that in the best case scenario, only 40% of these funds are ever collected. So certainly there's a clawback, but that clawback exists for all similarly situated circumstances where dollars are ceded to the state. So now you're using these dollars for this important governmental purpose, as indicated, I think, by the testimony from the district attorney, not only by virtue of his involvement on these boards, but also to save the state money in many, many respects, which directly and indirectly I think you could surmise. The next point that I want to raise, it's not clients' money, it's the interest of clients' money, IOLTA. The interest, it's the interest on the lawyer's trust money in what goes on. So that's what's being collected, from what I understand. No, that's not. Allison, you're saying no? No? You can answer.
The entire account can cheat to the state.
Yes. But the point is that if it is clients' money, certainly everybody's made every effort to try to find it. These are not situations. We see it now, thousands and thousands of dollars in various accounts that we see at the Comptroller's Office that are there that you can make claims against. Ultimately, it gets cheated to the state. So we see that happening. I'm sorry.
Correct me if I'm wrong. The interest already comes to the state.
That's right. And
you're
right.
These are the client funds.
Right. That's right. That's correct.
Okay.
You're correct. I'm wrong on that. So in any event, but the point is that it always goes to for only 40% in the best case scenario actually gets claimed. So if as they do in Oregon, the State Student Aid Commission or the Comptroller's Office sets up a reserve fund, which prudent business practices would say that would be the case, that there would always be money available to pay back the small amount and that this money over time. You're right. It is fair to say that this is money that would be going to pay down these student loans for these accounts versus to the general fund. That is true. But I think when you do the diagnostic in terms of the value to the state of what you're getting, and where else could you get these kinds of deliverables for this little amount of money? You got folks that are literally working for the smallest amount of money, and all you're asking them to do is to make sure they can pay their rent and eat peanut butter, so to speak, so they can do this work because they fundamentally believe, whether it's district attorneys or public defenders as public interest lawyers, and you get that value from people who are working their guts out to handle these numbers of cases for ordinary folks. Where can you get those delivery of services compared to what things cost us in the general fund?
But philosophically, if that's where we're going to use our money, shouldn't we put it in the budget? And I mean, you're trying to do a backdoor because we can't get the governor there, I guess, is the bottom line. And
correct.
And
kind of like the earned income tax credit.
Yeah, no, well, fair point. Okay, well, thank you, Senator.
That's exactly right. Call them as you see them. But it's true, and it's an easy hit. It's a smaller number. The impact is extraordinary. You see 40 lawyers, 100,000 cases a year at Neighborhood Legal Services, what, at 200 lawyers or more over an event horizon. And lastly, and my last point I want to make is that, what we see is that most of these young folks who come out of school and want to do these public service kind of things do it for about 2.5 years. The program's for 4 years. The hope here is that, in fact, if we give them a little bit of relief, we can give them some opportunity to stay there a little bit longer and provide the services as they become more knowledgeable in their field of law and provide this level of service. That's the hope. But certainly it's to support this kind of activity, which dollar for dollar, I don't think there's anything in government that gets you more professional services for less money, for more deserving people.
All right. Mr. Chu.
Thank you, Mr. Chair. I am supportive of this bill, happy to move it forward. I come at it from a slightly different direction, which is the statistic of someone who's been a member of the bar for the past 20 years of knowing that 90% of all attorneys serve the top 10% of all Californians. Flip side of that, 90% of all Californians is only served by 10% of all attorneys. And we need to have more public interest attorneys. As someone who was a public interest attorney, married to someone who is a public interest attorney who's still paying off her loans, and we do eat a lot of peanut butter. From my perspective, I think we need to have a broader conversation about whether low-income litigants ought to have some sort of right to civil counsel. We know that every day there are millions of litigants in the state of California who are losing eviction cases when they're tenants because they're unrepresented, who are domestic violence victims who can't get a restraining order, who are immigrants who, because they don't have legal representation, are being deported. And if they had representation, they could likely win their cases, and that has enormous societal costs and costs that government needs to spend literally hundreds of millions of dollars of general fund to address. So I'm very supportive of what you're trying to do here, and with that, happy to move this forward.
Thank you. That is a motion. Is there a second? Second. There's a second. That's fine. And the recommended motion is due pass to appropriations. Senator, I think this is a very clever funding source to a good program. And with that, I'll ask you to close.
Well, if this one doesn't work, I'll be back. Keep looking for clever funding sources or a new governor or whatever else it takes. The cause is just, the price is right, we're gonna. I worked on this many years ago, and I'm going to continue to work on this, as was indicated by Senator Chu. This is an important part of what we do. When we talk about the other side of this, we go out and give people these illusory rights, and what's the purpose unless you give them value? And the key is to do it as efficiently and effectively as possible using government resources. I ask for your support of this measure.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo? Chow? Chu? Aye. Chu, aye. Gallagher? Gallagher, aye. Garcia? Aye. Garcia, aye. Holden? Aye. Holden, aye. Mainshine? O'Donnell? Aye. O'Donnell, aye.
That bill is out.
Thank you very much.
Thank you,
members. Thank you, Mr. Chairman.
And that brings us to item number 3, SB 226. Senator Pavley.
Absolutely.
Morning, Senator.
Good morning. when I was first in the Assembly, Bob Hertzberg was Speaker at the time. It's nice to see him back thriving in his rightful place. This I'd like to present on SB 226. It's a groundwater adjudication bill. And I wanted to compliment the chair and particularly the staff on their excellent analysis. It really appropriately and accurately described this bill, but also the comparison with Assemblymember Alejo's bill. And just to let this committee know, we don't see a conflict in the two bills. Slightly different approaches, but consistent with trying to streamline the adjudication process. And Assemblymember Alejo's bill got out of my Natural Resources and Water Committee without any amendments, and it will be going to the Senate Judiciary Committee next week. And the jurisdiction, as we know in judiciary, is looking at due process related issues, but very good analysis. We may be using your analysis for future purposes, but
it's in the public domain now.
Yeah. We don't even have to go under the Freedom of Information Act. Most of you know, but just a real brief description on why adjudication is involved. First of all, we have about 23 basins that have gone through adjudication. In fact, at least 4 members of this committee, their areas they represent have been adjudicated. That means someone initiated a lawsuit declaring harm, whether it was subsidence or someone taking out more than their fair share of water or degraded water quality issues, a variety of issues. It's a long process, a very lengthy process. In Antelope Valley area of Southern California, out near Palmdale, Lancaster, Antelope Valley, this long process, they're over 15 years and counting. It's still not finished. There's a lot of time sinks, if you will, in going through this legal process of determining all the overliers of a groundwater basin, who gets how much water, and what reason. The courts take an incredibly long period of time. Attorneys do very well. I'm not sure the outcome is always the best. But anyway, so what this bill does, after we had a hearing last year, after the groundwater management sustainability bill that I passed was signed into law, we held a hearing in the fall, a well-attended hearing, universal agreement that we need to see how we can expedite, without compromising due process, the adjudication procedures. And what we did is take some of those suggestions that were relatively simple fixes, but still took up several years of time, and put it in this bill. And let me go over just what those few issues are. Basin boundaries sometimes take an incredibly long time, and we said, well, why not look at Department of Water Resources Bulletin 118 and use that, and then it could be modified if needed, but that's a good starting point, and spending a lot of time trying to figure out the basins. Notice and service, notice to known parties as provided in the Code of Civil Procedures. Unknown parties would be served by publication after making a good faith effort of a notification. Discovery would follow federal procedures which require disclosure of specific items without waiting for a discovery request. And one other reform on expert witnesses, also using the federal procedures as a good model for how to expedite that process. The goal of this is to reduce needless delays while protecting due process rights. Again, Assembly Member Alejo's bill is complementary, not in conflict with this, and I appreciate your aye vote.
Thank you, Senator. Your first witness in support.
Debbie Orrs with Community Water Center and Clean Water Action in support with amendments.
Kyle Jones with Sierra Club California in support.
Thank you. Additional witnesses in support. Witnesses in opposition.
Thank you,
Merkley,
Vice Chair, remaining members of the committee. Deanne Merkley with the California Farm Bureau Federation. We do appreciate the Senator bringing this forward. It was much discussed last year that this needed to be brought forward this year. There was not enough time last year to do that. We do, however, believe this is the wrong approach. Last year, it was stated many times that the Sustainable Groundwater Management Act would not impact existing water rights, and we feel this approach with the pieces of the bill that are in the California Water Code do impact existing water rights. And for this reason, we believe this is the wrong approach. Additionally, this makes other changes to SGMA that we believe confuses a very complex and complicated matter already. We're working with our members up and down the state, trying to get them to understand what they need to do to engage in the process, and this complicates that a little further. So with that, we respectfully ask for your no vote. Thank you.
Good morning, Mr. Vice Chair, members of the committee. Lauren Hajic on behalf of California Citrus Mutual, California Fresh Fruit Association, California Cotton Growers Association, Western Ag Processors Association, as well as other agricultural commissions and associations in opposition of SB 226. The main reason that we're in opposition of 226 is because we believe the approach in 1390 is a better approach where it focuses just on the procedural time sinks in the adjudication process and keeps the adjudication process in the Code of Civil Procedure rather than moving it into the Water Code and into the Sustainable Groundwater Management Act. We're concerned by that moving it into the Sustainable Groundwater Management Act. It would lead to some complications and further litigation in how the Sustainable Groundwater Management Act applied to all basins in California. There are 515 basins in California. Only 127 of them are subject to the Sustainable Groundwater Management Act. So in moving forward, if a basin that's not under the Act files an adjudication to gain certainty in their water rights, how does the court need to include the provisions of the Sustainable Groundwater Management Act in those non-SGMA basin adjudications? Further, by expressly adding, allowing the Department of Fish and Wildlife and the Department of Water Resources to intervene in an adjudication. We're concerned that this makes a fundamental change in water rights because it says that they can intervene to protect their interests. We're not quite sure of what all the implications there are of this, but under current law, any party can intervene to protect their interests, and we feel that that's the better way to allow agencies or other parties that aren't necessarily overlying landowners or cities of prescriptive right holders to intervene in adjudication, but allow the court to look at individual agencies and parties that want to intervene in that process. And for those reasons, we'd ask for your no vote. Thank you.
Thank you. Next witness in opposition.
Mr. Chair and members, Matthew Allen, Western Growers Association, also opposed to the bill.
Thank you.
Valerie Nera for the California Chamber of Commerce, also opposed.
Thank you. Anyone else in opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Senator, I appreciate that you working with Assemblymember Alejo. We did see that bill as it went through here, and it's true that we need to make sure we're aligning SGMA with the adjudication process. I think that's both of what you're both really trying to do, that we preserve the sanctity and ability to manage groundwater and also streamline the adjudication process, which is long since overdue. So I think it's a good bill, and the recommended motion is due pass to appropriations. Any other questions or comments, Mr. Wagner?
Yeah, I guess I'd like to dig a little deeper into 1390 because I'm hearing the senator say they're complementary. The opposition is saying they're not. Our analysis, on our side at least, suggests that they're not completely in alignment, and that the approach of 1390 is, is one that's had wide bipartisan support already. So maybe tell me again why you think the opposition's wrong on that point.
Well, first of all, they're sponsoring the other bill, so that sort of, and there's some nuanced kind of differences between the two bills. Last year, as you know, the Sustainable Groundwater Management Act, that's what they're referring to when they say SGMA, right? Was not supported by most of the people who like this approach. And one of the differences is we're putting these reforms, if you will, into the Sustainable Groundwater Management Act. It's a chapter, it's a subset, it's part of that. In fact, in the Groundwater Management Act, one of the speakers was talking about whether this just applies to high and medium priority basins. That's what's in the Sustainable Groundwater Management Act as the primary concern, the 127 of 515 bases. Assemblymember Leo's bill prefers it in the Civil Procedures Act. I'm not sure exactly why, and because I think it makes more sense to have it in the other, but it doesn't mean that the goal is working at cross purposes to implement the Sustainable Groundwater Management Act. They prefer it not be part of it, specifically the reforms, and operate on a separate parallel track. What we have decided in our office is the administration can look at both these approaches and either make a choice. They've got choices, obviously. Approve them both because it'll allow a parallel track, veto one of them, their call here. So it's the other minor differences, and it came out through our proceedings and our hearing that we had last fall, is sort of the interaction, if you will, that Justice Roby pointed out on groundwater adjudications or common law proceedings, and common law doesn't provide for protection of ecosystems. That's why in narrow circumstances, Department of Fish and Wildlife or Department of Water Resources could intervene into the debate or the discussion, if you will. So minor differences in approaches, neither one in conflicting with the Sustainable Groundwater Management Act. And there's no chaptering issues. We looked at that. And as I said, Assemblymember Leo's bill passed muster in our committee, and we got that out. Complex issues, sponsors of one bill, whatever.
Thank you. Seeing no other comments or questions, I'm still looking for a motion. The bill has been moved, and that is due pass to appropriations. Is there a second? And a second. Thank you. Senator, you may close.
Respectfully ask for your aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? No. Wagner, no. Alejo? Chow? Chu? Aye. Chu, aye. Gallagher? Garcia? Holden? Mainshine? O'Donnell? O'Donnell, aye.
Needs 3 more votes. We'll put the bill on call.
All right. Thank you very much.
Thank you.
Appreciate it.